Legal concerns in, what's the name of, legal concerns in contracting. So if that's the session that we're in here, and we're going to get started. So I have two of our contributors here on our news site. I've known Elizabeth for a little bit longer than John. Got introduced to John this past year, and both write regularly. How many of you follow our news on clearance jobs? Like, I should see every. I mean, that's my job. So I'm the face behind there. But so we have such great contributors, and both John and Elizabeth are lawyers who talk to a lot of candidates, probably a lot of companies, and share a lot of anecdotal plus takes on what the law has to say or different things that come out. So I'll actually have the two of you. I didn't turn yours on actually, John, but just give a real quick overview, just your experience in the industry, those types of things, and then we'll kind of kick off with our different questions. So.
Hello, my name is John Barry, and I'm an attorney. I've been representing security clearance individuals and government contractors since 1999. That's one of my practice areas. I also represent federal employees, police unions, and private sector employees and in various matters. But I would say perhaps one of my biggest practice areas is security clearance law. Probably takes 60% of my time these days. It's very interesting. As you all know, it's changing. It's amorphous. It sometimes defies definition. And I try and guide clients through all steps of the process from should I apply? Maybe I should wait to apply. Or do I need to have some help filling this out before I check no on that box on the SF-86 or the eQIP or whatever the electronic equivalent is going to be. I represent them in when they complete their security clearance questionnaires. I represent them in responding to any issues that may come up in the investigation. I used to be present at a lot of investigations with investigators until that kind of got out of vogue, and I sort of do it from the side. I also represent them in responding to supplemental information requests, statements of reasons, appeals, and reapplications, which is kind of a growth area. But in other words, I see all sorts of issues, just as Elizabeth does, and it varies, and sometimes there's no firm answer on a lot of these issues. And I know it frustrates a lot of contractors and security officers because sometimes there is no exact answer to the question that's being raised. But we try and do our best, and it's like we've got a pretty full audience, so we look forward to talking to you today.
Hi, I'm Elizabeth Baker Pham. I also go by Lisa. I'm a partner at College RV2Z Newman & Fitch, which is an employment law firm in Washington, D.C. I, like John, practice employment law and also am chair of our security clearance practice group. So as John mentioned, a lot of the same work, we have some overlap. You'll get a well-rounded view here today. And I would say something special about me, which you didn't ask for, but I'll share anyway. I really love the application part. I think that's a really, and we'll talk about that a little bit later, but the application is such a vital part of the application of the full process, right? The application is what guides the investigation. First impressions matter, as they always do, but in my opinion, very, very much here. So that's my favorite part of the investigation.
Yeah, we've had such good content over the years, both from, I don't know how many of you know, we also have a blog, which a lot of the users anonymously can submit. It's like Reddit, but not like Reddit to that level, right? And it's kind of like those one-off questions of like, I maybe was around a brownie that had something in it a week ago, but I don't know. But if I do know, should I say something and people weigh in and background investigators? But I feel like having both John and Lisa contribute on the site too, it brings a lot of that, not just, the potential PVQ that may or may not be here at some point. Like, will those changes happen and your insight on that, or notifications that come out from DCSA? It's helpful from that standpoint, but also the people that come across your desk at different points. There's just lots out there that, comes in different ways. So, all right, so kickoff, Lisa, what would you say you'd see as some of the top legal challenges facing federal contractors today when it comes to both security clearance and employment, things that you're seeing this year or in the past few years?
Yeah, so I think maybe surprisingly, I haven't seen a lot of change in the last 6 months. So I think the primary issues for security clearance holders, and therefore the people who want to employ them to do the work that they need a clearance for, continue to be marijuana, finances. Obviously, conduct issues will always be things that come up, but I think that the marijuana and the finances are still just really big themes. One thing I have seen in the last 6 months, and I think time will tell in terms of whether it's a trend or a blip, is a more aggressive stance on association with individuals who are in the United States without a legal status. And again, I'm not calling it a trend, but definitely some standout issues. And notably that I've seen it raised in the suitability and fitness context, which I would argue improperly, but nevertheless have. And so something to keep an eye on.
Has there been a difference, just to follow up on the marijuana side, just because it is such a hot topic on, I know a lot of candidates wonder and they're not sure, there's a lot of misinformation out there. Are there ways that that's changed over the years maybe? Because it is like, it doesn't seem in many places as strict as it once was. So there's been changes somewhat in how it's handled, like not always like never anymore, or even with the drug classifications changing. Has that made it worse, muddier, or like it's still the same as it always was before an issue? I don't know if that makes sense, but.
No, it makes perfect sense. And you're right. So I took the narrow view of your question. So looking at it more broadly over the last few years, I mean, absolutely. We've seen some changes in marijuana, favorable in my opinion, more leniency. I would say more practical application given where we are as a country, where we are with local laws and really the social norms. So for example, if you look at DOHA, which is the body that hears all security clearance appeals and revocations for DOD or DOD adjudicating folks, they used to take a really hard line. Once you complete the SF-86, you can't use marijuana. And therefore, any use after that, you're pretty much done. And that's not the case anymore. They get it. They get that people read the blurb that they used to say was the line in the sand and still go, but it's not illegal, right? It is illegal. It's illegal on the federal level. And therefore, it's a hard no. But so many people get confused because you can buy it at the store on the corner and you don't need a medical marijuana card and you're not going to get arrested. And so there's this confusion, and it just honestly, I think, this is my speculation, but created a problem, and they had to react to that, but still within the confines of the fact that it is illegal. And the scheduling, I think we'll probably talk about a little bit later in terms of prospective changes. Yeah.
No, that's helpful, because I know there's just, it almost makes me wonder, like, how many of you get asked, or maybe it doesn't come out in the recruiting call or in any of the initial stages, but do you get asked, is this going to be a problem? So would it be helpful to have, like, here's what we would recommend you do if you're asked, like, because we always recommend go talk to a lawyer, like just have an open conversation. Like that's the way I usually lean, but obviously you guys probably say that.
Yes. I mean, I would agree. And I think really the proactive communication to folks, because so many people, right, they say, I would have stopped if I had known. I thought it was okay. And I think the other thing that I hear too, that I hope no one here does, is I was told not to put it down. I was told, just don't say anything. Oh my God, man. Like the difficulty overcoming an omission, because it's going to come out in the interview. They know everybody's using it. It's asked. If you answered no, they're going to ask you, are you sure? And it's just so much more difficult to overcome than being candid. And I know John, I'm sure, has some information on that as well.
Yeah. I mean, in terms of just DOHA, it's exactly as Lisa said. What I've noticed, though, is some intelligence community agencies have gotten more aggressive on marijuana usage. I deal a lot with NSA cases, and not so much the CIA, but I've had issues where it's even dug down into, have you used CBD oil? And can you show what level of THC is in this CBD oil? And I've had people who have had medical marijuana cards and still been turned down. So it's still a big issue. Like some agencies like DOHA is getting more reasonable, where some intelligence community agencies are getting a little bit more aggressive. And, you know, as has been said, it's probably good if you have some time in advance to get advice from a lawyer to try and get ahead of it. Or avoid it. I've had plenty of people, you know, that have come recently and said, "Oh, I used marijuana like 3 weeks ago, and I'm applying to the FBI. What do you think?" I'm thinking no. You know, just give it. Well, with them, give it I don't care what they say. Give it 10 years. No, give it a few years, and you can get by it. But it's gotten so confusing because all the news that's come out has been, well, we're liberalizing this. The states are reducing the issue by changing their state laws. But then everyone points to the Controlled Substances Act and says, well, you knew it was wrong. You had training, right? Yeah. Okay. Thanks. So it's still an issue, but like I said, thankfully, at least the major processor at DOHA is getting far more reasonable, at least in my opinion.
Okay. Feel free if you have questions on that. Oh, I have a question here. Awesome. Go ahead. He's got a mic right there.
So if someone applies for a clearance and they were prescribed marijuana medically by a doctor, are they 100% going to be turned down for a clearance? Or is that a case-by-case basis?
Case by case. Yeah, case-by-case basis. But continued use of marijuana, even medical marijuana, is a no for the federal government because it's a controlled substance. But prior use, it's case-by-case, absolutely. They look at all the mitigating factors, the explanation, whether the individual was aware, to what extent they were aware, when they stopped, why they stopped. And, you know, that's something that the application, everybody, so important. When you're disclosing the bad information, you need to disclose the good information too, because it really helps set up the context for the investigator and the adjudicator, but, you know, at every stage.
Okay. So just to clarify, you're saying that it would be a prior situation. If it was current, it would be a no. It wouldn't be a case-by-case basis. It would have to be something that was prior as opposed to current.
I hesitate to draw many firm lines, and I think part of that being current is sort of, I'm a lawyer, sorry, subjective, because current at the time of application and then never again, or continuing. Continuing is really where I think I would say that's going to be a no if I were, you know, generalizing. Continuing. Now, once you realize that you can't do that, you stop. I would say that's case by case, but maybe John has a different opinion.
No, it's definitely case by case. I mean, I have a case right now with DOE, and the issue is the person, you know, had medical marijuana usage, had a card, everything for his particular medical condition. But, you know, it came out that he was using it. So he hadn't reported it, which is obviously a huge issue. But that wasn't the main issue for DOE, believe it or not. It was that he had used it and it was illegal. And, you know, some agencies are different, you know, they've tended, DOE, in my opinion, has been very touchy on both drugs and alcohol. It's totally case by case. I mean, if, I think the individual is going to have a difficult time. I mean, we're going to bring in the doctor and everything to try and show this was the best effective method for him to use for his particular condition. And we'll see where it goes, but we very well might not prevail. So it's definitely an issue.
Thank you.
Come on, Mark.
I was just curious if either of you have seen any issues like in the last couple of years with like, I guess, accidental like CBD use. Like I know a lot of products have it infused like in gas stations and things like that. And sometimes like I have an inactive clearance right now, but like I know friends that have like almost bought something like not realizing it. Like usually it has writing, but it's still hard to tell sometimes. So I was just curious, is that actually an issue? Or if people report it, it usually like people don't care. As long as you report it, I guess.
Yeah, I mean, I think that's, it could still go either way, but I think that's a little bit better on the facts, because I mean, if someone goes to the gas station or wherever, I mean, you see all these different products. I mean, God knows what's in it, and whatever state you're in, sometimes you can sell marijuana right there or THC. If you don't know, I've had a couple of cases, and I don't know about everyone else, but those have gone pretty well, because the person's like, listen, I didn't know it had a component, looked like, I'm trying to think what it looked like. It looked like just some concoction, and, like energy drink, Red Bull or some combo. And those have turned out okay. They've taken full responsibility. They should have known better. But I think when you knowingly, do it, I think it's worse. But what's your take?
I mean, I think that one of the nuances here is that there are so many different products, as you were saying, but right, CBD, hemp-derived CBD, that is not federally illegal unless the agency has a policy against it. Like I think active military still does, but don't quote me on that. That in and of itself, I believe the most recent guidance is not forbidden. However, because it's so poorly regulated, it could cause you to pop positive on a drug test, and saying it was just CBD is not a defense. So they put folks on notice. It's not illegal, but it could cause problems for you, and it's not a legitimate defense. Now, there are cases where individuals are able to show this was the product I was using. It says it's legal. They test it, and there are websites that do that, right? Here's the batch and the percentage, whatever. The safest bet is don't use it, but it is distinguishable from marijuana-derived CBD or THC or things that are illegal at the federal level. So the Farm Bill really kind of created this gray area that is helpful to some people, but for clearance holders can cause problems that have to be carefully mitigated.
Okay, thank you. Yeah, I mean, like as somebody that had a security clearance, I was always like, as more states like keep legalizing things, I was always like worried. I was like, if half the products in the stores you go to are going to have stuff in it, it's like kind of annoying to have to worry about everything you buy is going to have it. Thank you.
Well, I'm going to move on to the next question. Otherwise, we're going to have to rebrand this talk as a marijuana talk. I will say we'll add that in next year. We'll see if the room packs out. But one of my favorite squirrel pictures that we have for some of our pictures, it's him like, I didn't know it was that kind of brownie, So anyway, so John, pivoting, how are you seeing, especially this year, I feel like this is, potentially seeing more and more of this baby this year, but seeing federal contractor clients adjust workforce strategies, given federal hiring freeze, waves of displaced federal employees. Is there anything you've seen kind of shifting with some of the narrative shifting this year?
Yes and no. I also represent a few federal contractors, and it's interesting because on first glance, and kind of what a lot of people are doing are wait and see, because you just don't know what's going to happen. But as I've thought about this and I saw this question and I thought it was a great question because I'm like, okay, where have I seen this before? Well, like in the 2000s, early 2000s, I remember there was a lot of federal employees being let go because they were going to transfer it into contractors, which they did, and they put them in, to a large part in Northern Virginia. And, I'm starting to see this some more, and it's starting to come out in the news some more. I mean, people need to do the work that a lot of these federal employees have left. And I've represented so many federal employees in these kinds of situations, as well as you have, Lisa, that what's interesting is the work still has to get done. So I am going to say that probably within the year, you're going to start to see a huge pickup in contractor opportunities and contracts, out there because the work just needs to get done. It's not getting done at a lot of agencies because a lot of people have, either been decided to leave, decided to retire, been forced out, whatever have you. And the work will still need to get done. So I'm pretty optimistic about the trends for contractors going forward, at least in the next maybe year and stuff, because they're not going to, probably for the next few years, they're not going to replace a lot of the federal employees, but they are going to hire contractors to do these functions. So that's what I'm seeing.
You said, I'm going to jump just so we can keep with time because I think this is a really, sometimes I see so many different questions pop up on the site and all of a sudden they just bubble up in my head right now. But this one's good in that how should contractors handle situations where an employee loses their clearance mid-contract? Are there different things that you've seen, and this is either one of you can answer, like over the years that maybe it's gone well or maybe it's gone poorly and, different ways to handle that?
Okay, John, I'll take this one. The majority, as John does, I do work with employers, but predominantly I work with applicants. And so I may be a little biased in saying that I think it is not the best move to just cut them loose when they have an issue with their security clearance. And I might actually be misremembering what you said. Did you say lose their security clearance or have an issue? Because I think like those are a little bit different.
Lose, but I'm guessing it would be, even if it's an issue, like if they got a statement of reasons or something popped up, essentially you still can't bill to the contract and continue working or show up at your government.
And that's really what comes up most often. Yeah. And I would say that's what comes up most often. And I talk to those folks who are saying, I got fired and I asked why, and I finally figured out, and they don't get a statement of reasons a lot of the time. The employer learns that there's an issue and they kick them out the door. And because of DOD policy, and DOD is such a prevalent entity in this space, loss of jurisdiction, for anyone who doesn't know, DOD, if you don't have a need for a clearance, will not adjudicate. They won't process an investigation. They will not adjudicate the issue. And so these people get stuck in what I like to call purgatory, and it's not a great place. And it's hard for them to get another job. So I would say what I like to see for folks is when, the employer is able to slot them in a position where they will have work for them as soon as they become eligible again. Because a lot of times it's stuff that can be resolved. It just needs time, and it's not the individual's fault. The government is slow. We all know, not blaming anybody, but it's a fact. And so it's not that everyone I talk to in this position has this terrible thing that's going to lead them nowhere, right? They just need the time and opportunity to resolve it. And so, giving those folks the opportunity to do that. If there's non-cleared work, fantastic. That's not always the case. I get that. But if there's the ability to keep them sponsored in a position, work ready for them, when they are eligible again, that's ideal. Yeah.
That's helpful. I feel like our time went very quickly. We did get a tiny bit of a later start, but if you have any questions, you can always shoot them over to me and I can pass them on. I'm sure your information's out there on the internet and everything. We can also provide that information for you. You can send it in or just Also, if you're on our news site, if you just click the category security clearance, that's where all of their articles will pop up, and you can even search for them by their author name and see all the different things they've written before. And it can answer a lot of the questions that because that's the thing with the security clearance process, it's always the one-off questions, and usually the answer is it depends. It's a case by a lot of times because they're looking at the whole person. There's a lot of factors there. So, but yeah, you can find out a lot more information there. But I don't want to be the reason to keep you guys from your break before the rest of the recruiting sessions. So that's all we have. Right. Thank you. I did shut up. Thank you guys. Sorry.